Okay, it's now time for our first keynote presentation of the conference, Military and Operational Cooperation in Outer Space. Providing this presentation will be Professor Laurie Blank. Professor Blank is currently the Special Counsel to the General Counsel, Department of Defense. She is also a clinical professor of law and the director of the International Humanitarian Law Clinic at Emory University School of Law, as well as a core expert on the Woomera Manual on the International Law of Military Space Operations. Please join me in welcoming Professor Laurie Blank.
Good morning. I'm going to probably not stand behind the podium because it's a little too mature for my taste. So it's really quite a pleasure to be out here in Colorado. I don't usually get out here in the winter without strapping on my skis. This is one of the few things that would get me out here without some moguls. So it's really a pleasure. I want to first thank our hosts and organizer, General Dickinson, the USSPACECOM Office of Staff Judge Advocate, in particular, Colonel Pennington and Melissa Murphy for all the help in putting this together and getting us all here. And then the Law, Technology, and Warfare Research Cell here at USAFA, in particular, Colonel Vienna, Major Grunert, and Professor Biller. I also do need to start with a disclaimer that in my current role in the Office of General Counsel, I'm speaking in my personal capacity. My remarks are not representing the views of OGC, DOD. I'll come up with a few more acronyms. My dogs, anybody else. And I think, was it you, Jeff, who said maybe by the end of the time, it doesn't even represent my own views. But what I want to talk about this morning in thinking about the theme of cooperation in space and building on last year's theme of responsible behavior in space, because they kind of go together in some ways, right? You have to think about what is responsible behavior and what do we agree as a shared conception of responsible behavior in order to effectively have cooperation and to use that cooperation productively. And so what I want to talk about a little bit this morning is thinking about those through the legal lens. How do we think about some kind of fundamental definitions and thresholds and concepts and frameworks in order to try to figure out where are some of the hard questions that might challenge our ability or at least motivate additional thinking and additional work in that idea of cooperation and responsible behaviors. So I'm going to build a little bit on the remarks that General Dickinson offered in sort of setting the stage a little bit to think about this. He gave us a great overview, right, of thinking about space as a strategic and operational domain. I don't have to tell everybody here. You're here because you already are engaged in that space and are in thinking and learning about it, right? And it plays a significant role in the assertion of national power through various instruments of power, not just the military instrument. It's an essential component, right, of thinking about the central role of information in competition and conflict. And we all see today, I'm betting everybody here has at least one phone or device, right? So we see what role information is playing. And within information, we can think about misinformation and disinformation and all kinds of tools in that space. That has become a major, let's call it battleground, competition space, and hopefully cooperative space in thinking about conflict, pursuing national objectives, and so on. The need to collect and process and fuse and disseminate information on a global scale and in a timely, if not speedy manner, is critical to gaining an advantage and to pursuing success. General Dickinson mentioned that, right, he described space as congested, contested, and competitive, right? I love the alliteration there, but I also like the picture it gives to us, right, in thinking about space. As he mentioned, we have an expanding number of players and objects vying for finite locations and operationally advantageous orbits, and also an expanding number of capabilities in outer space. I think to the layperson, space is just really, really big, and it's way out there, and there's an infinite amount of space, right? To infinity and beyond, all these kinds of statements and sayings that we grew up with, this conception, but it's not, right? It might be really big, but it's also really, really busy, and it's congested and competitive. So as we have this increasing number of actors, this increasing number of capabilities, including counter space capabilities, we're going to see an increasing amount of tension. And tension demands cooperation, right, in order to address it, right? It pushes us to think about how can we cooperate? How can we understand where we're going to be having competition? How can we understand how to perhaps forestall that competition, turn it to our advantage? How can we think about how to either forestall or, if need be, engage in more competitive and even conflict-oriented activities? So that brings us to international law. International law has an important role to play in helping to address and hopefully alleviate these types of situations of competition, tension, contestation, right? International law helps to build clarity and predictability and enhance stability. Law is at its base about expectations. What do we think is going to happen? If A happens, what do we think is the response, right, in B and C and D, right? One of the reasons, right, that law helps to promote clarity and stability and predictability is because it helps us understand and predict and anticipate what will come next. It also gives us the tools to be able to counter when what comes next isn't what was expected or understood as the next appropriate step. And so international law is an important tool to promote shared understandings governing state behavior, right? And shared understandings obviously are what help us get to cooperation. So in December of last year, at the Combined Space Operations Initiative Principles Board, which I'm sure has a proper acronym, but I wasn't able to figure out how to pronounce it, defense leaders from several partner nations, the US and several partner nations, emphasize the need to continue to promote a rules-based international order and responsible behaviors in space, while cooperatively addressing challenges to the safety and security of space-related operations. They highlighted guiding principles: freedom of use of outer space, responsible and sustainable use of space, partnering while recognizing sovereignty, and upholding international law. Small tasks, right? Easy stuff. So how can we take that as sort of a call to action in thinking about international law and a role in cooperation in space? So obviously there's outer space law, right? And a number of you here are obviously engaging and teaching and working in that all the time. So what I want to do is, in addition to that, bring in 3 other international law regimes that are relevant and essential to this discussion, and highlight some of the interesting questions and challenges in thinking about those frameworks, in thinking about those definitions, in how they might play out in the space domain. Jus ad bellum, right? The law governing the use of force, the law of armed conflict, and the below the threshold, left of boom space, intervention, sovereignty, countermeasures, that space. And what can we think about in terms of hard questions, tensions in trying to understand how definitions that we may have established in the terrestrial domain, but then we put them into outer space and they get a little bit more complicated, right? What can we take away in thinking about maybe what we need to think about more, or what we can anticipate as hard questions? So when we think about those goals set out in December, promote the rules-based international order, promote responsible behaviors in space, and address challenges to the safety and security of space-related operations, we need to then think about some additional things. The legal frameworks and thresholds, as I mentioned, but also who are the relevant actors? States, obviously, non-state groups, commercial entities, space tourists, that's one of the latest. All different kinds of actors. We need to think about who the actors are in thinking about how the law works. What about pressure points that we might see as we see this increasing variety of actors and variety of capabilities in a critically important domain? What about gaps in the law? What about opportunities for exploitation of those pressure points and gaps? What about opportunities for consensus, for debate, and ideally for shared understandings and cooperation? So in sort of thinking about all of those things together, I'm going to focus on a couple of interesting and challenging questions in the law of armed conflict space. But before I go there, I want to highlight a couple of interesting issues from the other two legal regimes that I mentioned, just to kind of, get us warmed up, little stretching exercises before we go into law of armed conflict. In the jus ad bellum, right, the law governing the use of force, this law has some important goals, right? Minimizing the resort to force, maintaining stability and order in the international system, preventing the escalation of disputes and the spread of conflict. Well, those are all highly relevant when we think about space, right? But we don't have a whole lot of state practice to guide right now, right? One of the ways we understand how the law works, in addition to looking at treaties, is to look at state practice and hopefully some opinio juris that gets us understanding the customary law as well. And one of the things about space, and we see it in cyber as well, is that it's hard to identify sometimes the state practice because states don't always talk about what they're doing. You can't necessarily see what they're doing, see with the naked eye, the way you might be able to see perhaps an invasion of a neighboring country with tanks and other, aircraft and so on. We can see that. We can't see stuff in cyber and space. And so thinking about these questions is helpful. The basic framework for the jus ad bellum, right? We have the prohibition on the use of force in Article 2.4 of the UN Charter. We have 3 exceptions to that prohibition. The consent of the state, the territorial state where force is being used, UN Security Council authorization, or self-defense. There are hard questions in the space context about where the threshold for a use of force is in the outer space context. If we want to think about how this legal regime works and how we are going to try to find shared understanding so we have more predictability, more clarity, and so on, kind of need to have a good understanding of that core threshold. One of the challenges, of course, is that in the terrestrial domain, we don't actually have a definition of use of force. It's a little bit of I know it when I see it. This is obviously a use of force. That one, well, that's a harder call, right? That's ultimately how that law has played out, with basically the lower level things, lower level questions being left gray, murky, and oftentimes because there is a desire to maintain order and prevent disputes, we don't tend to see pushing of the envelope at that lower level. Now we take a not entirely defined threshold and not entirely defined framework, and we put it into outer space, and of course it becomes a little bit harder, right? We know our basic understanding of a use of force is an act causing death, destruction, or injury. That we can pretty well identify in outer space, right? A direct descent anti-satellite weapon destroying another state's spacecraft, right? We could come up with lots of examples. On the Woomera project, I know several of you were on the project with me, at least for the first few years. Every time we needed an example, we just kept blowing satellites up all the time. And eventually we became a little bit more diversified in our examples of trying to think about how different things of law would play out. But you took a lot of lawyers without a lot of variety, right? We needed our space experts in there to say, well, actually, there's other things that happen, right, in outer space. That's one of the challenges, right, is often a lack of imagination, a failure of imagination in thinking about how the law is going to work. The challenge, of course, is when we think about non-kinetic acts. When would those be a use of force? We have this same challenge in the cyberspace. And what about acts causing a loss of functionality? Right? There's still a lot of thinking to be done in this space in the international law community. Is a permanent loss of functionality a use of force? What about a temporary loss of functionality? What kind of functionality being lost? What is the potential harm from that loss of functionality? So these questions, right, introduce potential uncertainty in how the law works. And uncertainty can lead to opportunities for exploitation, or it can lead to a slower pace of finding that shared understanding and cooperation when a response is needed. One of the really interesting questions I think that comes up in the space context when thinking about self-defense is, and it's driven by the specific nature of outer space law and the particular rule of state responsibility, right, ensconced in outer space law, is which state has a right of self-defense when an action triggers, right, when there's an armed attack that triggers the right of self-defense? Is it the launching state of the object that was destroyed, attacked in the course of that armed attack? Is it the state of registry? They may not be the same. Is it the state of nationality of the company or entity that owns that space object? Is it the state receiving the services from that space object? And then what if there's a consortium involved on either side of that equation? Who has the right of self-defense? We think so much in the jus ad bellum space about when the right is triggered and what you can do in response, necessity, proportionality, and so on. But space adds in the possibility that we're sitting here scratching our heads going, well, wait a minute. Is it your right of self-defense or is it your right of self-defense? And what if we get it wrong? Now we have a whole nother round of self-defense claims coming about. It gets a little bit confusing, but it also makes it hard to figure out when the law should be, how we apply it and in what situation. We can see some of these same challenges in the below the threshold space. In that arena, our extensive and one might say nearly complete dependence on space for military and non-military functions. I mean, I used GPS to get here, driving here from the Denver airport. I knew it was south, right? But I needed a little bit more than just drive south, right? So I needed my GPS. I've tried to explain to my kids how we used to go places without GPS. And when they say, how did you get there? How did you know where to go? And I said, I called the place I was going, and their eyes go blank. Call? Right? Because their phone is never on, right? They don't hear when it rings when you call anyway. I would call and I would ask for directions and I would write them down and then follow them. Blank looks. And then if I made a wrong turn, I would have to figure it out. They would say. And then they go back to their phones, right? So we barely even realize, right, the extent of our dependence. But this dependence provides countless opportunities for malicious and disruptive behavior and actions, right? And space law offers some opportunities but not much to deal with that, right? You have the due regard obligation. You have, things like harmful interference, but it's a little bit murky. We haven't really seen due regard actually implemented and used, right? We haven't seen a lot of states demand consultation under that provision. So we don't actually know when it's appropriate or how it would work. The principle of non-intervention, core principle of international law, prohibits coercive acts affecting the state's domaine reservé, which are areas of activity that international law leaves to the state to regulate. Freedom to choose your own political, social, economic, and cultural systems, for example. And it must be coercive, right? It must be an attempt to force the state to act in a particular way that it otherwise would not. You can think maybe about some forms of satellite signal interference possibly could violate the prohibition on intervention, right? If you considered jamming a broadcast signal and then spoofing with coercive political message to try to affect a regime change or change the results of an election. But again, we have to think a lot about exactly where those lines are, right? And when a state could assert that it was the victim of a prohibited intervention. And then think about countermeasures, right? Which would be one possible response that a state could take. And here we come back to that same question driven by the particular nature of state responsibility in the space arena. A countermeasure can only be used in response to a breach of international law. So first of all, the quote, nasty or malicious action has to be an internationally wrongful act. But then you can only direct your countermeasure against the responsible state. Same questions about who's the responsible state, right? The launching state, the state of registry, and we can go on and on. How do you know? And then would we quote the international community think about, well, that countermeasure was unlawful. So now they have a spiraling effect, right? Well, now can someone else take a response to that, and so on and so forth. Okay, so those are, again, some introductory warm-up exercises before we get into thinking about law of armed conflict. My bias, right? My particular area of interest in this space, so to speak. There's so many fascinating issues. That's why there have been multi-year projects thinking about all of these questions, not just in the law of armed conflict space. But let me throw out a few. What about identifying and characterizing the existence of an armed conflict? We've gotten pretty good at that in the terrestrial domain. We know what Common Article 2 and Common Article 3 of the Geneva Conventions mean. We have quite a fair amount of jurisprudence and state practice and the practice of international organizations in identifying the existence of armed conflict, who are the parties to that armed conflict, and so forth, right? We have pretty settled definitions and thresholds. We know that the law of armed conflict applies in the space domain when there is a situation that triggers the law of armed conflict, right? We don't have questions about, do we even take LOAC into space? Article 3 of the Outer Space Treaty settles that for us, along with a general, widely accepted consensus to that effect. But how do we know, right? Same question, right? Driven by the nature of space law. If there is an attack in or through or from space, and that was the potential trigger for an IAC, which states are party to that IAC? It's a pretty consequential question, right? If there's confusion about that, the difference between I am a party to an IAC and I'm not a party to an IAC is pretty stark, right? That's not like, well, it's okay, it's fine with one way or the other. It's a pretty big difference. That's why we don't have the law of armed conflict apply all the time, right? It's a great body of law, but it shouldn't apply all the time. So we need to know for certainty who's the party to the conflict? Is there an armed conflict? So that's a really interesting question. Right now, we haven't had a situation in which a potential international armed conflict is potentially triggered solely by actions in the space domain. So of course, we don't have the state practice to try to figure this out. If we already have an existing IAC, we know that the law of armed conflict will apply to things going on in space related to that conflict. But might they bring another state into the mix? Right? Again, important question. What about military astronauts, the status of persons? We sort of think through the progression of how you teach and talk about LOAC, right? You start with, is there a conflict? How do we know? Okay, so that's one set of hard questions. Then you need to talk about the status of persons, right? Right kind of conflict, right kind of person, that analysis. Well, the same rules, civilians, combatants, et cetera, all those are going to apply the same way. But we get some interesting and fun, depending on, I guess, your sense of fun, questions, right? Triggered by the intersection between LOAC and outer space law. So military astronauts. I know I talked to at least one person here who was working at NASA this year. Are they combatants in an IAC? Or are they envoys of mankind? Right? LOAC says if you're a member of the military in an IAC, you're a combatant. Outer space law says if you're an astronaut, you're an envoy of mankind. And you are protected, like really, really protected from just about anything. That's a technical legal term, really, really protected. In case you didn't know. Well, which is it? Right? We don't have some magic lawometer that we type in the different things and ask it to figure out which body of law is going to win that battle, so to speak, right? This could come up in the context of targeting. Are they lawful targets at all times except when they're ordered to combat? That would be a LOAC, strict LOAC view. Are they never targetable because they're envoys of mankind? That would be a space law sort of strict approach. Might it be something in the middle? Law doesn't usually love things in the middle. Going back to that idea of clarity and predictability and stability and all that. The middle is this gray area, it's this murky space. But maybe that's what happens when you put two bodies of law with potentially competing purposes into the same place and in trying to answer the same question. Would we think about it almost like DPH? So if you're a military astronaut who's doing research and it's unrelated to the conflict, even though you're in the military of the country that is engaged in that conflict, maybe you're not targetable. If you're a military astronaut who is engaged in combat-related, conflict-related activities, maybe you are. But then that's a whole nother level of analysis we have to then go through. What about if that military astronaut splashes back down to Earth and lands somewhere within grabbing reach of the adversary in that armed conflict? Is he or she a POW? That's what LOAC would say, right? Or an envoy of mankind with an immediate ticket back home. That's what space law would say. I'm pretty sure I know what the adversary country would argue in that scenario, right? But what's the right answer? And maybe we don't know until this actually comes up. Sometimes that's how law works, right? But these are questions that are hard ones to figure out and open up opportunity for pressure points on the law. Depending on how you answer that, you can begin to see how that then pushes the law in one direction or the other. And then you build on that and build on that, right? It's very rare that the answer to a hard question in law just stops there. It tends to then influence how we think about the next hard question and the next hard question. And then the law begins to change. not always a bad thing, but we need to think about that before and in the process of trying to answer these questions. We can't think about them solely in the abstract. I really like the military astronaut one. I just think it's fascinating. Okay, so what about targeting? That's where we would go next, right? Conflict classification, status of persons, then we get to conduct of hostilities. And here, some really interesting questions. So one of the things, as we all know from the last 15, 20 plus years in all the discourse on the law of armed conflict, on military operations, protection of civilians has been a central issue in the discourse, in the development of operational art, in just look at the, for example, the CHIMRAP, right, is huge effort by DOD right now. It's a critical issue. It should be at the center of our discussions, right? We know from history, from current analysis of the extraordinary harm to civilians, to civilian populations, to society from armed conflict, right? Without even getting into, are there violations being committed or not being committed? The fact of war inherently is linked to the fact of significant suffering among civilians. So it has been a centerpiece of this discourse, and appropriately so. Most of that discourse has been thinking about urban warfare and warfare in densely populated areas and so on and so forth. When we talk about military operations in outer space, we might think, whew, I have a little bit of a respite from the hard questions about protection of civilians, because where is space? Really far away. Are there a lot of civilians in space? No. You know, there's a couple of people on the International Space Station. At least last I checked, I mean, unless there's been some news flash of a new colony, et cetera, right? So you think space is way out there, civilians are way down here. Okay, we can think about different questions. But in actuality, space presents a lot of really interesting and hard questions in thinking about this same question, protection of civilians, and how the law works in the targeting space, not just in the targeting of the adversary's capabilities, but in thinking about what that means for civilians. Targeting inherently, right, demands an understanding of civilian infrastructure, population, patterns, and effects. That doesn't change when we take targeting into the space domain. But we have to think about these things a little bit differently. And here, for me, we see some really interesting and challenging pressure points on the law. So anytime we talk about targeting, we're talking about distinction, proportionality, precautions, right? We all know how those work. Distinction, who can be lawfully targeted, right? Combatants, members of organized armed groups, civilians who are directly participating in hostilities, military objectives. We have those definitions down pat, right? We could probably have a little competition here in how perfectly everybody can recite them word for word in this room, right? We know how those work. We know where the hard questions are. But, right, take them into outer space, and some of those hard questions become potentially unanswerable questions, or at least today, unanswerable questions. So one important question in thinking about targeting is, what is a civilian object? You can't target civilian objects. So if you can't target them, you need to know what they are, right? Otherwise, it's really hard to follow that rule. Distinction rests inherently on having good definitions and good implementation of those definitions. Who is a combatant? Who is a civilian? What does DPH mean? What is a military objective? What is a civilian object? We've got to have those down pat in order to actually put the law into practice, right? Before we even get to what, if you looked at the general discourse, you would think is the single hard question, which is proportionality. You got a lot of hard questions before you get to things like proportionality and precautions. So many space objects have military uses that we have to think a little bit more discerningly about when is something a military objective and when is it a civilian object, because we run the risk of the definition of military objective just swallowing every single thing in outer space. It's really hard to come up with something in outer space that doesn't have a military use, or in thinking about the definition of military objective, purpose, meaning intended future use. Right? Really hard. About the only thing we could come up with in some, evening discussions, usually accompanied by a drink or two, during the Woomer project, was like the Tesla that got launched into outer space as a promotional thing. And of course, the other day someone said, yes, but couldn't that still be used as a projectile, right? So pretty much there's not much out there. But it can't be the answer that there are no civilian objects in outer space. That just can't be right. Because then you essentially have no rule left. Right? It would be the equivalent of saying, which we know is absolutely wrong, well, if you put out an order to evacuate, anybody who stays in that area, they're obviously automatically lawful targets. That's not how the law works. Right? It's not like, oops, you didn't get out in time, so sorry, you're no longer protected from attack. So we need to think a lot about what is it that takes an otherwise civilian object, meaning it's sent up into space to do civilian things, whatever it's doing, what would turn that into a military objective? It can't just be the fact that it could be used that way. Or even, right, is purpose, as we understand it in the definition of military objective, enough? Well, we have to maybe be a bit more discerning in how we think about purpose, because again, that could swallow things. And we also still need to think about the fact that, right, states may well feel that they have a fair amount of leeway in characterizing objects as military objectives. And think about the fact, again, that it's hard for everybody else to see these things. So it's hard enough in the terrestrial space when you have debates about whether or not an attack was lawful and this building or object otherwise, now has been destroyed. So it was being used as a C2 node, or it was being used, rockets were being launched from here, except the thing is gone now, right? So in the external discourse, it's hard to demonstrate military advantage, why something was a military objective, if it's gone, completely destroyed. You can't show the things that you knew were there that made you determine it was a military objective. Take that now into space where none of us can see what that is, and you have a much harder discussion to have, because in today's world, it's no longer so easy to say, well, yes, this is what we knew it was doing, right? The rest of the community outside the state doesn't just say, oh, yes, I see, you said it was being used for this purpose. Of course, we'll believe you. There's always going to be debate and different perspectives. So that's one hard question. What about when there's overlapping civilian and military uses? Right? What level of contribution to military action is sufficient to mean something is making an effective contribution to military action? And of course, what if you have multiple payloads on a satellite? Now you've got things with other states, right? Owned by other states. Boy, it sure gets pretty messy. This leads to one of the hardest and I think most interesting questions, a question not resolved here on Earth, which is the idea of severability of military objectives. In some way, I think space is going to offer maybe a gift to the discourse, because it's going to demand that we think harder about this question, right? It's a hard question here in the terrestrial domain, but we're going to have to come up with more tools to think about this. What is this idea of severability of military objectives? It's the question of when you have something that's got multiple parts, which part is the military objective? Is the whole thing a military objective, right? So for example, a building with multiple wings, right? And the adversary is using one wing for military purpose. Is the whole building a military objective or just that wing? Right? We don't actually have a good answer to that right now. We have a lot of good discussion about it, right? But most of the discussion about military objective tends to look at whether something fits the definition, right? This idea of severability is which part of the something is the military objective and whether the different parts need to be separated out, right? So that you say that's a civilian object, that wing, and that wing is the military objective. Generally, right, we think that a military objective needs to be specific and distinct from other objects. The law says you cannot treat an area, right, that might have several distinct military objectives as one big military objective. You can't take a whole part of a town where there's 4 different lawful military objectives and just say that whole part of town is a military objective. That would turn distinction on its head, right? But how is it always possible to be that precise and that careful? We think about this in the space context. How do we think about a satellite bus with multiple payloads, 1 or 2 of which are clearly meeting the definition of military objective? But is the whole satellite bus the military objective? Just those payloads? And kind of the kicker question is, does that depend on your ability in targeting, your capabilities, your weaponeering abilities? The law does not work where we use capability to decide what's a military objective, right? The law has a definition of military objective and then, right, a methodology for targeting. So if in fact we start using capability to decide what's a military objective or which parts of something are a military objective, that may factually be the answer, but it is changing the law, certainly the implementation of the law. So we need to keep that in mind, right? That we can't just say that and move on and not think about what pressure that puts on the law. So some would argue that the whole satellite is a military objective, viewing the satellite and all the payloads on it as a single object. It's not hard to see how this then leapfrogs us back into the conflict classification discussion, because those different payloads are not all going to be magically from the same state that is the one engaged in the conflict. There might be multiple different launching states or states of registry or other states involved. And now potentially that conflict could just have escalated. It may be the most straightforward option in thinking about the law, right? But it raises concern about civilian harm because it wouldn't take into account any harm to the civilian payloads and the civilian components, because the law does not say, right, when you attack a military objective, that military objective is the target. Proportionality and precautions are about minimizing the harm to civilians not part of the military objective, right? And civilian objects not part of it. We don't think about proportionality as how much harm do you do to a military objective. That's more of a law enforcement construct, right? So this kind of straightforward, maybe traditional approach might be the easiest way to apply the law, but it would encompass a lot of sort of harm unrecognized to civilian capabilities, civilian objects, and so on. Alternatively, one might say, well, only the military payload would be the military objective, right? But is that really possible operationally, right? And are we then essentially placing the definitions and the understanding of the law on the shoulders of capability, which I think presents some challenges. The Tallinn Manual, in thinking about this in the cyber context, took a middle ground. And it said the attacker must consider any harm to the clearly distinguishable civilian components of the military objective. If it's not clearly distinguishable, then the whole thing is a military objective. That's a good middle ground, but it raises some concerns about how we think about proportionality and precautions. And this whole idea of clearly distinguishable is going to change as technology evolves. And the question is, can the law keep up with that evolution? And what do we call an object, right? How specific do we need to be in thinking about that? So I think this question really introduces a lot of, again, what I would call pressure points on the law. Are we going to start using capability to drive analysis? It's fairly well settled that one party to a conflict, just because it has greater capabilities, does not have greater obligations. It may have greater tools to carry out its obligations, but the law applies the same to both parties in a conflict, right? And you don't have different law because you have precision munitions or anything else. You may have obligations to use those in certain circumstances, right, in order to attack a target, but it doesn't change your legal obligations. If we start thinking about capability driving how we apply the law and how we analyze what's a military objective, we might start to see a change there. We also get into questions about what level of confidence or certainty or doubt, right, to use all those different words, is relevant in making these determinations. And these are also hard questions, right? Hard questions that all of emerging technologies are raising across the board, right? When we think about judgments being made by human brains, we think about reasonableness. That's the touchstone of the law of armed conflict, the reasonable commander, and so on. When we think about machine capabilities, right, particularly in the context of AI and autonomous weapons and things like that, I don't usually want my calculator to give me a reasonable answer. I want my calculator to give me the actual answer. And I want it to be the same every single time. And guess what? If my calculator messes up, I throw it out and I get a new calculator. But can we take that concept of certainty into the law of armed conflict? It's not made for that. It's not designed for that, right? It would change the law if we all of a sudden started understanding that we had to be certain without knowing what certain means, right? I mean, I can be fairly certain I know what it means with a calculator. I can be fairly certain even things like, that aren't quite as intelligent, even like a toaster. When you turn it to toast, you expect your bread to toast, right? So how many times have you put a piece of toast in the toaster and you have it on for a while and nothing's happening, and then you realize that it's set to bake, right? Because you did something else in the toaster and forgot to switch it. It's not the toaster's fault, right? That's human error. But if you do set it to toast and instead, I don't know, it does something else, air fries or something, you wouldn't keep that toaster. You wouldn't say, well, that's within the zone of reasonableness. I understand, it's a gray area, right? But, right, as soon as we start thinking about how much confidence how specific we need to be, how separate an object, one part of an object needs to be from the other, and how well we can know that or not know that, we have to think about these questions. What is reasonableness? What is certainty? What is doubt? All these things that we already think about and are hard with respect to human judgment, but we mix in machines where we don't expect them to make mistakes. We mix in technology that we don't expect to be wrong, and we're going to start changing the law a bit. We also would see, right, if we start using proportionality and precautions to account for the harm to civilian aspects of what might be different parts of a military objective or of an object that has different component parts, we're also changing how the law works, because the methodology of targeting is distinction, identify whether or not something is a military objective, a lawful target. Then move on to what precautions can be taken, right? All feasible precautions to minimize harm to civilians, and assessing proportionality. But we don't apply those with respect to the military objective. It may be that ends up what we start doing. But then we've got to be really careful that we don't start applying precautions and proportionality outside of that context, right? And start changing the law so that now analysis of an attack on a military objective on land starts to mix in. Well, I mean, could you have caused less harm to that military objective? That's not what the law requires in any way, but it could evolve that way, right? Because analysis over here is going to bleed into analysis over there. One last point before I wrap up, and this is, I think, an equally challenging question, maybe harder. What is civilian harm, right? If you want to talk about proportionality, if you want to talk about precautions, those are inherently focused on minimizing civilian harm, right? Proportionality talks about refraining from an attack if the expected harm to civilians is excessive in relation to the military advantage gained. Okay, well, when we bring in space, what is civilian harm? And where, even maybe the bigger question, where is that civilian harm? So we know generally civilian harm is death or injury of civilians, damage or destruction of civilian objects, civilian property. And normally we think about that where the conflict is happening, right? We don't generally, if you're thinking about an airstrike, an artillery barrage, anything, and the conflict is between, purple state and red state, you don't tend to think about whether or not civilians in green state might be killed, might have damage to their property, and so on. It's factually not relevant. It's geographically not relevant. But now we go into space and that changes entirely, right? Because space objects can provide services to civilians in many countries around the world, which means that action against those space objects or space capabilities can result in harm to civilians in countries around the world. So when we think about civilians, we actually have to say which civilians, right? We tend, when we talk about LOAC, we tend to kind of think about our civilians and enemy civilians. The law emphatically does not think about civilians that way, but we at least sort of geographically think about that, right? Where is something happening? But all of a sudden, we might need to think about concentric circles, right? There's the immediate circle of geographically where the conflict is, but then there's increasingly expanding concentric circles of where harm to civilians might happen as a result of actions in, through, or from space in the course of that conflict, right? So satellite is taken out, and in addition to the military capabilities that it provides to parties in the conflict, which is why it was taken out, maybe it also provides capabilities for search and rescue on the other side of the globe, or tsunami warning, or any number of things. And that's taken out, and now there's harm as a result 8,000 miles away. Hard to conceptualize as you're thinking about trying to figure out what can be done or what precautions need to be taken in the arena of that conflict, but space may require that. So when we think about how we compose the commander's battle staff and what capabilities need to be included, right? There's all kinds of discussion about what do you need in terms of understanding the civilian infrastructure in the area of the conflict. Do you need civil engineering knowledge? Do you need a knowledge of how the water infrastructure or the power infrastructure or any number of things of how understanding the culture of the community? Well, now you might also need to understand stuff that's happening on the other side of the world, right? So all of a sudden, how we define civilian harm becomes critically important in being able to implement the obligations, right? And then the idea of reverberating effects. This has been talked about a lot in the space context, but I don't know that we have a good answer, right? We saw some cool pictures during General Dickinson's remarks, right, about the space debris. I think it was 1,500 pieces, or was it 15,000 created just from Russia's ASAT, right? So when we think about civilian harm, right, how far out do we go? Also interesting questions as part of the discussion of proportionality here in the terrestrial domain, right? Do you include, right, if you're engaging in an attack that might compromise the power grid, do you include the harm, the damage that might cause to the water treatment plant? Probably yes. But then what about each successive fourth, fifth, sixth order effect? How far out do you go in thinking about civilian harm? Take this into outer space, and on some level you have an unanswerable question, because space debris doesn't go away, and it breaks up more and more, and it hurts more and more, causes more and more damage. So can you ever make a proportionality assessment, right? Or are you just sitting there going, well, I don't know. I don't know how to quantify the amount of harm, because I don't know that my brain can, quote, calculate, even though obviously it's not a calculation. My brain can imagine, can conceptualize out that far. If the debris is going to be there for decades and it's going to break up in potentially predictable but not entirely predictable ways, how do you think about that? Or do we just sort of put a line and say, well, nope, we're going to just think about proportionality and this harm to civilian objects for one cycle, whatever that would be, right? Or two turns around the globe, or whatever it is. And that's it. That's all we're going to do. That's one way to think about it, right? But it's not really a lawyerly answer. The last thing in this area is warnings, right? Law requires that you provide effective advance warning of attacks that may affect the civilian population. Same question, which civilian population? Who do you have to give warnings to? What understanding do you need of all the capabilities and payloads on a satellite or another space object in order to properly provide effective advance warning? That's a significant amount of analytical capability that has to go on there, right? Or do we simply say, insufficient nexus to the conflict, we're just going to draw a line. It's only civilians in the areas of the conflict. But then you're leaving a lot of harm unaddressed. So I'll leave it there. Hopefully some of you have answers to some of these questions. And thank you, and happy to take some questions.
Ma'am, thank you so much. We do have some questions that have flown in from online. Our first question is, I'm going to edit it just a little bit, Captain Kabili. It's from Captain Diana Kabili. And what she asks is, how should we prepare or advise kind of incoming government attorneys, maybe JAGs, maybe other types of attorneys, who are interested in this field of space law, in studying these kinds of issues? Is there a particular line of study that you might advise them to start to get into, even as early as undergrad, to start pursuing some of these topics?
So that's a great question. So one thing, and this goes back to conversation Jeff and I were having just a few minutes before this, which is the importance for lawyers working in any of these areas to have some basic understanding of technology. I certainly would benefit from understanding technology a lot more. And to be able to come in with that foundation that you can build on is essential, because it's going to get less and less likely that one can engage in a practice of law where you're not touching on these issues all the time. And if you have to get spun up from zero each time, it's not very effective. The other thing that I would say is to not think about any one area of law as a silo, but to really think about the law in an integrated manner, right? So you might think that, well, there are people who focus on space law, and then there are people who focus on law of armed conflict. Okay, but when you put them in a room, they have to be able to have a conversation, right? And not just be like, well, this is what I know. Well, this is what I know. Okay, well, we're stuck, right? So to learning the law in an integrated manner, thinking about it that way, rather than sort of like, Tuesday, Thursday is my class on this subject, and Monday, Wednesday is my class on that subject, and ne'er the twain shall meet, to actually be constantly thinking about how they're relevant to each other, right? And how they can work together and maybe take productive ideas from one and inject them into the other.
So you may have already answered this when you talked about severability, and that there may not be a good answer to this yet. Recently, the Army rolled out the test for its virtual desktop infrastructure. And I'm just kind of curious about your opinions. I personally think it's great because you talked about your toaster. A toaster could run processes from a virtual desktop. But with kind of that move to digitization, you talked about the blurring of lines between civilian and military. If we move into a virtual desktop, I'm kind of curious what your thoughts are when personal devices and basically all commercial like internet lines or anything like that basically then become accessible to a military network, and kind of what your views may be on that kind of blurring of lines there as we kind of go forward into this more digital age.
So can I ask you to give, for my benefit and everybody else here, like 2 words on the virtual desktop concept?
Okay.
What it's
I'll try my best. I'm a paralegal. I'm by no means a technical expert. But my understanding is that a virtual desktop, basically you utilize either an app or just a program, and the actual desktop itself is run at like a mega server, rather than you having to run your desktop off of your personal device. So you could use a cell phone, a personal laptop, or anything like that to then use any unclassed network, any civilian network, to then access this server, and then run your processes from there. So that's kind of where I'm curious about with that access going into that.
Yeah, so I think you've hit the nail on the head in your question, which is that those of you who work in government, right, you're always having at least 2 phones, this and that. This stuff can be on that phone, this stuff can be on this phone, et cetera. And you keep them totally separate. You don't do personal stuff on this one, government stuff on that one, for any number of reasons, right? But this idea conflates them such that anything you're using at any time would, to the extent that there is the server, the particular issues being data or capabilities in a conflict, would be military objectives, so would be the device by which you're accessing it, right? It would be really hard to make an argument that I'm using my iPhone, my personal phone, to access this and send message traffic or make decisions or, give my opinion on something or even receive information. But my phone, that remains a civilian object somehow, magically, right? It would be hard factually to make that argument, right? And so I think it does, it's the same kind of question that is raised anytime that things get mixed together, right? So there's been some really interesting papers written on, should there be specific rules or at least policies regarding the use of certain satellites, whether it's nuclear warning satellites or other capabilities, so that they remain separated from other military capabilities, so that you could argue that no, they're not lawful targets, right? Because they are not connected. It's the same question. And I think it may sound great, right? But you have to follow the path and see, well, what happens if we do this? What happens if it's sort of the 21st century version of, well, the school is a really good physical space for this armed group to make its headquarters, because, you know, it's got water and bathrooms and rooms and like clear space around it, where they cleared space for the playground and any number of things. Well, that's great, except that you're now making schools look like targets, particularly that school, but then any school potentially a target in an armed conflict, right? And so there's a reason why the law wants things to stay separate. And it's going to be like more and more stressors when you put that into the digital and the tech space, for sure.
Thank you. Air Vice Marshal Jennings from the UK, from the Royal Air Force. Thank you for that. That was really interesting and thought-provoking. I wonder, in terms of cooperation in space, it's a two-part question, I think. The first is, for cooperation in space, particularly between allies, how important is consensus in terms of understanding our approach to the law? And second, if it is important, where are the real tensions that we currently see between us as allies in terms of reaching that consensus, bearing in mind some of the difficult questions you posed? Thanks.
Thank you. So the interoperability obviously is a critical question. And there are going to be times that two allies, however close, are simply not going to agree down to the final letter on how the law should be interpreted, how a specific question. So I would start by saying we have a lot of experience in nonetheless working together, right? We have lots of examples of interoperability, even when two countries don't either have exactly the same treaty obligations. So, you know, this one's a signatory to the cluster munitions, that one's not, et cetera, or have the same understanding of a particular concept, self-defense or something else, like individual self-defense. So we have a lot of experience with that. It doesn't forestall effective cooperation, for sure, right? Otherwise, we wouldn't have the word interoperability, right? We would just have agreement, right? You wouldn't need that fancy word interoperability if you didn't have to somehow navigate those different things. Where the lines fall between interoperability and yikes, we can't quite get there yet, because like we're kind of still at cross purposes. I think those come about, sometimes you can look ahead and foresee them. So, right, especially we might see this in the below the threshold space, where you don't have as many overt examples of cooperation and interoperability, because so much of that happens not just that it's below the threshold, it's that it often tends to be below the attention level of the general like international discourse, right? So states might be singularly focused on those things, but we don't see as much conversation about it in the broader space, which then means that there's more maneuverability for states because they're not out discussing the same way they are in the armed conflict space, where there is now a constant conversation on, you know, between states, you know, sort of in the more formal space, states, international organizations, and so on, but very much in the informal discourse with advocacy groups and academics and so on. There's just a constant conversation going on there. And so I think probably these things are going to come about iteratively, right? That organically, right? That something's going to be like, whoa, we need to sort of soften the edges here. And maybe that's all. That's often all it takes. It's not we have to actually agree. We need to soften the edges so we can both find our own comfort space and move forward. And I think that's where we're gonna end up. And some of these hard questions about, you know, where are the lines on what's a military objective? Those may be then the sources of, you know, red card authority and things like that, because you can't reach actual agreement. There's going to be reasons why different states take different approaches within that zone of reasonableness. And so I guess I would think about it as the first step is getting in the zone of reasonableness. When you're in the zone of reasonableness, you have interoperability, right? It may be harder in some situations than in others, but at least you're in a shared space. But within that, you may have hard and fast, like, yep, can't go there scenarios. And those begin to get sharpened through practice. And you can't ultimately really sharpen them until you kind of actually have the question and you're like, whoa, didn't think it was going to come up that way. Okay. So I have hope.
Okay, please join me in thanking Professor Blank. Okay, I think your remark seriously did provide us with a wonderful framework for the remainder of our conference. So I want to thank you very much. And as a token of our appreciation, I'd like to provide you with our conference coin. Thank you very much.